If you got fired tomorrow and had to prove it was illegal, what would you actually show a lawyer? Most people can't answer that, and that blank spot is the reason so many legitimate complaints end up going nowhere. Winning an employment case comes down to evidence that already exists before you need it, which means the work has to start well before anything goes wrong. Today, I'm going to tell you what to keep, where to keep it, and the deadlines that can quietly end your case before you even get to file it. This is legal education and not legal advice, so anything specific to your situation is going to need a lawyer who can actually look at your facts. Let's start with what's happening on the other side of the table, because it explains why documentation matters as much as it does. A lot of times, you become a problem at work the moment you make a complaint. Performance reviews that used to be fine start highlighting things nobody mentioned last time. You get put on a performance improvement plan with goals that feel designed to fail. Your manager starts including HR in emails about small behaviors that never seemed to matter before. None of that paperwork shows up by accident. It shows up because somebody in the company understands that if this ends up in front of a judge or an investigator, the side with the stronger file usually walks away as the winner. Your job, starting now, is to make sure the stronger file is the one sitting on your computer. So, what actually counts as evidence? The single most powerful piece of evidence in an employment case is something the law calls a contemporaneous record, which are notes you wrote at or near the time something happened. Courts give these notes significantly more weight than memories you reconstruct months later. The format that works best is a dated timeline, where every entry answers the same handful of questions. What was the date and time? Where did it happen? Who else was present? What exact words were said? What happened immediately after? Here's the detail that hurts more cases than people realize. Your notes have to record facts instead of feelings. Writing something like, "My boss was clearly discriminating against me again today," is almost useless, since that's an opinion nobody can verify. But if you write, "On March 14th at 2:30 p.m. in the third floor conference room, my manager told me the team needed someone with more energy, and then removed me from the Peterson account by end of day," is completely different, because every piece of that sentence can be checked against calendars, emails, and witnesses. Your feelings might be completely correct, but the law runs on dated, specific facts. So, where should you keep these records? This is the part where employees hurt their case. Never, under any circumstances, store your documentation on company systems. Not your work email, not your company laptop, not the Dropbox folder your employer pays for. The second you're fired or even suspended, you lose access to this information, and there's no easy way to get it back without a lawyer or a subpoena. Keep your timeline in your personal computer, a personal notebook, or a note-taking app connected only to your personal email. Emails should also be forwarded to your personal account as they come in. Text messages should be screenshotted with the date and sender visible. Performance reviews should be downloaded and stored off company systems the moment you get them. If company policy specifically prohibits forwarding certain emails, follow the policy and just save the metadata instead. This includes the date, sender, subject line, and a short summary, because forwarding privileged or confidential documents can actually get used against you later. One more thing worth mentioning here. Whether you can legally record a conversation at work depends entirely on your state. Some states are one-party consent, meaning as long as you're in the conversation, you can record it. Other states require every person on the call to agree, and recording without that consent can be a crime on top of the recording being inadmissible. So, check your state's rule before you press record. Here's something that sounds contradictory but matters a lot. To preserve certain claims, especially retaliation, you usually need to report the issue internally first, because that report is what the law treats as your protected activity. The problem is that the second you file it, the counter-documentation starts. The way to thread this needle is to make every internal complaint in writing, or to follow every verbal conversation with a short email that says, "This email confirms our conversation today, during which I reported the following." That one email creates a date, a subject, and a record, and it forces HR into a written response that becomes a part of your file. And while we're on the subject, remember that HR is not your friend. Not because the people who work there are bad, but because their actual job is to protect the company from liability. The minute your complaint starts to look like a lawsuit, their documentation effort shifts from understanding you to defending the company. Keep that in mind, put everything in writing, and spell out exactly what happened. This next piece is very important, and missing it has destroyed otherwise strong cases. If you want to file a federal discrimination claim with the EEOC, you generally have 180 days from the date of the discriminatory act to file, or 300 days if your state has its own fair employment agency, which most states do. If you miss that window, your federal claim is permanently excluded, no matter how good your evidence is. Internal HR investigations do not pause that clock. You can wait 6 months for HR to finish looking into it and watch your EEOC deadline expire while you're being patient. Once the EEOC closes your claim through investigation, mediation, or dismissal, they issue what's called a Notice of Right to Sue. From the moment you receive it, you have exactly 90 days to file your lawsuit in federal court. Courts treat that window as a fixed rule, and cases filed on day 91 have been dismissed on that basis alone. If you're sitting on an active claim right now, talk to an employment lawyer before the notice arrives. So, what actually wins these cases? 3 patterns show up in nearly every successful employment case, and they should shape how you build your file from day one. The first is temporal proximity. This is just legal speak for suspicious timing, because getting written up 2 weeks after an HR complaint looks very different from getting written up 2 weeks before. The second is pretext. This means the employer's stated reason for disciplining or firing you shifts over time or doesn't match their own paper trail. So if your termination letter says poor performance, but every review for the past 3 years says you exceeded expectations, that contradiction can help your case. The third is comparative treatment. This is when a coworker outside your protected class did the exact same thing you got punished for and faced no consequences. All 3 of those only exist as proof if you've been keeping a record of everything. And an employee has a better chance of winning if they have a fully detailed and documented file.